There were so many new filings Monday and Tuesday. I was going to go through and do them one by one, separately so they weren't so long, and I thought I'd bust through 3 of them today. But I just got through 1, because once I got started, I just really got into it. I'm covering documents 394 and 395, which are basically the same thing. 394 is the letter that gives all the details, and 395 is the declaration that goes with it, along with 4 exhibits. This particular one was written by Kevin Fritz, and as I've said before, whether it's Friedman or Mitchell or Fritz, they write in very similar styles, and I love their style. And another thing I love about it is it's a lot of the stuff we said when I covered Blake's motion. It's kind of like that episode became a motion, but of course a million times smarter than I could ever do. There is a good amount of shade in multiple ways that will unfold throughout this episode. But that was the inspiration for this thumbnail. We see what's representing Blake's burnt to a crisp feet. And cool Kevin offering some shade. Let's get started. So 394 starts off with a bang. It does not disappoint. It says that last week, Miss Lively referred to Jones Works as a co-conspirator of various Wayfarer parties. They did not miss that. That was a beautiful thing to see that show up because it made us all start to wonder, are Blake and Stephanie starting to turn on each other? Because as stated before, they were bitter enemies. At the beginning of all this, while Stephanie still represented Wayfarer, she put so many attacks on Blake that Justin and Jamie called her off. They said, please stop, don't do this. And then her chance at revenge came along and she tied Blake into it. And as I said, I'm sure they went back to hating each other. So, as this starts to fall apart, I imagine they're going to be pointing fingers at each other. And so this word wasn't lost on Wayfarer. He jumped at the chance to say, co-conspirator, you called her that, Blake. And then he adds to it, Miss Lively and Miss Jones, 2 alumni of the Van Zandt subpoena scheme. And see, that's what I love about it. Ezra and Mike Gottlieb, when they write, it's just nasty mean girl stuff. It's not witty, it's not clever, it's just nasty. But these little things, they just make you giggle when you read them. But it says they have apparently now realigned to jointly seek to delay their respective depositions. So he's calling it what it is. When they can help each other, they're aligned. When they don't want to take the blame, they're back to pointing fingers. Everybody can see it. Well, not the Blake fans, but we can see it. So as I always like to draw attention to, it states the federal rule that they have to follow for this particular topic, which is 16b4. And this is addressing changing the scheduling deadlines. That's the rule that you follow for this. And in those rules, we learn that such a request has some qualifiers. You have to show that despite due diligence, the deadlines couldn't have been met. In other words, even if they tried their best, couldn't happen. Now, do you just have to say it? No, you have to demonstrate that it exercised diligence in conducting discovery by describing what discovery it conducted in the time period originally scheduled, and that there are circumstances that were not foreseen at the time and that it was not your fault. And here's one of the big shades about this one. They went through, probably because they're getting sick of Liman denying their motions and granting Blake's. This time, a lot of their cited cases are actual cases of Judge Liman's, where he has made these rulings. So now, it's going to look really stupid if he goes against himself, his own rulings. So they're not just from his circuit anymore, they're actually his rulings. And so we find the first one, it's Furry Puppet Studio versus Fallout Boy. This was a request for an extension of discovery, and in his decision he says, first, a scheduling order is an order, just like any other order of the court. In other words, it's like a command. You have to do this. He mentions the Rule 16 that we're talking about that makes clear that the judge has an important role in expediting disposition of the action. It's all about securing the just, speedy, and inexpensive determination of every action and proceeding. And that's an essential mechanism for cases becoming trial-ready in an efficient, just, and certain manner. And he talks about the good cause that's required, as stated from this case Peterson versus Home Depot, that's also mentioned in Kevin's document. It says good cause is likely to be found when the moving party has been generally diligent. The need for more time was neither foreseeable nor its fault, and refusing to grant the continuance would create a substantial risk of unfairness to that party. So those are the things you must have. Then he tells you the things that are not qualifiers. It's carelessness, an attorney's otherwise busy schedule, or a change in litigation strategy. Keep these in mind. The party seeking an extension should demonstrate that it exercised diligence in conducting discovery by describing what discovery it conducted in harmony with the original schedule, and that there are circumstances that were not foreseen at the time of the order, and it's not the party's fault that caused this need to request the extension. The movant should also set forth the remaining discovery to be conducted, so you're supposed to list all that out, why it's important and could not have been conducted earlier, why the requested time is necessary, and how allowing additional time would contribute to the just, speedy, and inexpensive determination of the matter and any prejudice it would suffer if a modification is not made. When he made this decision, he said that this letter did not describe in sufficient detail or any detail at all the status of discovery, including what discovery has been done and what remains to be done, nor does it describe whether and how many depositions remain to be taken, why they are necessary, and why they cannot be done in some lesser amount of time, or why settlement discussions could not have been commenced earlier. Nor does it describe what events transpired after, and it gives the date, that were not anticipated on that date, and he denied it. We remember Blake's letter. They didn't list any of these things. So based on Judge Liman's own prior decisions, they have not met this standard. And then we get our first subheading. He says Miss Lively and the Jones parties have not exercised diligence in conducting discovery. And now he's going to state his case. How have they not been diligent? Blake has not served notices of deposition for any of the Wayfarer parties. That deadline's coming up very soon. How has she not served a single one? She did do one for tag because of everything. That's what she's most concerned with. There is no mistake in it now. I've always thought it. I've slowly been saying it, and now we can scream it. This is what Blake cares about. Not any kind of fake SH claims. This is all about she doesn't want people to talk about her. She doesn't want people to not like her. That's prime importance. And here's another example of why we can say that, because who's the first one she gave notice for? Tag. That's Melissa Nathan's company. But even though she did that, she ended up canceling it. So he goes on that the Wayfarer parties took the initiative and proposed various dates for their own depositions. Since they weren't doing it, they said, hey, these are the days you can do this person and that person. Remember, they gave them a nice little schedule of when they had availability. Nonetheless, even though they did that, Blake's counsel has not confirmed the dates. They haven't said, hey, we're not available those dates. They've not said, how about these dates? They've not said anything, except for to complain and say, oh, judge, they only gave us so many dates available. Well, why are you running to the judge with that? They gave you the available dates. It's your move. You're supposed to say, okay, let's book those dates. Or, we can't do those dates. How about these dates? None of that. They just ran to the judge and said, oh, they only gave us these few dates, without even attempting to see if they would work. So as he says, if they preferred other dates, they should have requested them, but instead, they uncooperatively complained. And they still have not explained their unavailability. They say that based on this case, Gardner Alfred versus Federal Reserve Bank of New York, that denied motions to compel depositions where plaintiffs failed to timely serve notices of depositions. So they're saying, don't even start trying to compel these because you've skipped all the steps that you're supposed to do first. And she's also complained about the sequence of depositions. Apparently, she wanted it in a specific way. But if we turn to this case that's cited, so taking a look at his decision in this case, another Judge Liman decision, this is a case involving parties and third parties. And there was a situation with discovery. While that was going on, one of the parties had discovery stayed. They had the deadline for their deposition notices, the deadline for their depositions, and plaintiffs were seeking to compel defendant to produce these third parties for depositions on the grounds that their depositions were noticed before the close of discovery on October 20th. So they're seeking in order to compel defendants to produce two parties on the grounds that their depositions were noticed before the close of discovery. And then they have these third parties that were listed in initial disclosures and that there would be no prejudice to defendant in taking their depositions out of time. So now we have a situation of they wanted it in a specific order. Plaintiffs must show good cause for scheduling order to be modified. They must show despite due diligence, and he repeats the same thing we just saw in the last case about due diligence, and then he shows, and he quotes the case we just read, the Furry Puppet Studio versus Fallout Boy, and he finds that the following factors are not compatible with the finding of diligence and do not provide a basis for relief: carelessness, an attorney's otherwise busy schedule, or a change in litigation strategy. So using those standards, plaintiffs have not shown good cause why the depositions of Mucciolo and Lynch, which were noticed in October, could not be taken before February. So there's no good reason. You had plenty of notice, he's saying. Plaintiffs have shown no cause at all why the other 3 depositions could not even have been noticed, particularly when plaintiffs were aware of the depositions. These people were mentioned in the initial disclosures. Now you remember the initial disclosures is at the very beginning of discovery. And he mentions that it's the very purpose of Rule 26A1 to ensure that a party knows at a very early date of the witnesses its opponent intends to use to support a claim or defense, so that the party can notice any depositions it will need. So in this case, we didn't talk about it. There were 2 parts to this. One was a motion to compel discovery, and one was a motion to compel depositions. And so the motion to compel depositions is denied, and the one that's granted is about discovery. But that wasn't relevant to this case, so we didn't cover that. And now we get to Stephanie. She was served with a notice of deposition. She said, "I'm not available," and then refused to provide an alternative. Now remember, she jumped in on Blake saying, "Oh, I didn't get the footage." We'll address that in a moment, but I'm sure you were all asking the same thing I was. Why does she need footage? And then she never responded. Nevertheless, because Miss Lively and Jones' party's obstructive tactics, more shade, have made the existing deadline for the completion of depositions untenable. For that reason, they have no objection to an extension of such deadline to September 30th for the depositions. However, moving on to the outstanding requests for production and interrogatories, they object to this. They say, fine, we'll extend the deposition time period. There's no need to extend the document production. And then they discuss her motion. They say the crux of the motion is an extension of the fact discovery deadline in the case management plan and scheduling order is needed. So what Blake and Stephanie claimed, the crux of their motion, is they need to extend the discovery deadline because they've only recently received the footage of the film. Here comes some more shade, which notably Miss Lively credits herself as having edited and thus reviewed. So, in other words, why does she need it? She knows what's on those videos. Why can she not do a deposition until she's seen it? And he's not done with that yet. When Blake filed this motion, it got all her fans in an uproar, saying how unfair it was that she didn't get it till July 1st, and she didn't get all of it. But as it says, she acknowledged herself that she requested it on February 20th, and that she knew from the case plan that fact discovery and depositions were to be completed by August 14. And yet, she never moved to compel the production of it by a date prior to the case's plan of July 1st. So the plan always was July 1st is the substantial completion of document production. Not all. We talked about that, remember? A lot of people confuse July 1st as meaning all discovery had to be turned in, but it wasn't so. It's the substantial completion. She always knew that that was the deadline for it, though she might not get it till then. If she wanted that specifically, she could have filed a motion to compel the footage. She never did. And we know that she compelled other things, so if this was so important, so why not compel it early if it was going to be a problem for you? It wasn't turned in late. The bulk of it was turned in by July 1st, and guess what? That's the rules of the case plan. It wasn't late. They didn't play dirty. There was nothing wrong with it. They turned in the substantial completion of the footage on the day it was due. He's saying they apparently anticipated their purported need for the footage, but failed to compel an early production thereof. And remember, one of the requirements is that they have to show prejudice it would suffer if a modification is not made. So now we move on to that. They say there's no prejudice to Miss Lively in receiving the footage in the weeks before or even after her deposition. The footage is recordings of incidents where either A, Miss Lively herself was present and thus does not need the video to present her case. We just said that in the last episode. If she has an honest claim, she has the truth. She doesn't need to watch the video. Almost everyone who has to testify in a case about what happened to them does not have footage of it. They have to just use their own recall. She should not be relying on this video to present her case. B, if she was not present, the footage is irrelevant. The Wayfarer parties would be justified in withholding the footage until after Miss Lively's deposition. Here's the thing. Remember what we said? So that she cannot improperly tailor her deposition testimony to conform thereto. I said we were going to get back to that, and now's the time. And it points out this Costco case. Also in the Southern District, the same place this case has taken place. And this one's cited because it says it granted protective order delaying production of surveillance video until after plaintiff was deposed about the alleged incident. And it cites another case that supports that, also in their circuit. Let's have a look. This was a case of a slip and fall at Costco. Costco files for a protective order to withhold their video footage of the accident until the plaintiff is deposed. So Blake's fortunate they didn't file one of these. I'm sure her daddy judge would have denied it. But look at this. While walking through the entrance door pushing the cart, Dora says that she tripped on the rug that was rolled up in front of the Samsung TV demo. She landed on her knee and struck her back onto a TV stand. On February 22nd, she served a verified bill of particulars in which she states that she was caused to trip and fall at the front entrance of Costco's premises due to the negligence of Costco and its store employees in failing to remove, repair, or replace a rug placed at the entrance of the store. She states this in response to interrogatory number 4. Remember the interrogatories. Those are sworn statements. But now Costco files this protective order because they say the allegations in the discovery responses and the medical records are at complete odds with what is depicted in the store video, thus warranting withholding the video in order to preserve its impeachment value. Doesn't that sound like Blake? In her original complaint, what she said happened during the dance. Once the video was released, it wasn't so. It was so bad, she had to change her accusation on her amended complaint. In their requests, they say if the court's inclined to deny our request to make her have to wait for the deposition, then we respectfully request an in-camera inspection of the video prior to making any such determination. And so the judge granted this. They were sent a thumb drive of the footage for the judge's review. She decides that the defendant has met its burden to show good cause why a protective order should be entered. Based upon the court's in-camera review of the video footage, there does appear to be a discrepancy between what is depicted in the video footage as compared to plaintiff's accounts of what occurred. Thus, there's an independent factual basis to warrant a stay. Goes on to say courts in the Second Circuit, this is where they are, routinely delay the production of similar surveillance videos until after a party's deposition to preserve the impeachment value of certain evidence, to discourage parties or their witnesses from tailoring their testimony to conform with their prior recorded statements or actions. And the Second Circuit courts have delayed this production of audio or videotapes prior to one or more depositions in order to prevent the defendant or its witnesses from tailoring their testimony to conform with their prior recorded statements or actions. Moreover, there will be no real prejudice to the plaintiff in receiving the footage after her deposition. The footage is a recording of an incident where plaintiff herself was present, just like Blake. Thus, she does not need the video to present the substantive evidence in her case. And so, the defendant's letter motion for a protective order to delay production of the video footage of plaintiff's alleged accident until after plaintiff's deposition is granted. And the legal citations involved this second case, this Popo versus IN Risk Services. So apparently, in this circuit, that's pretty standard. So Blake has no right to demand to get to see all of this video footage before her deposition. But before we move on, when I saw Costco here, the way they've been citing Judge Liman's own rulings, I remembered that in that article about the federal judges who were not disclosing their financial conflicts of interest, even though they found more than 130 judges, they didn't name very many. In this article from CNN, the only judge they named was one, Judge Liman. We're going to review this again because he presided over this case for 18 months. During the course of the case, 3 months before he dismisses it with prejudice, his wife sells this stock. How convenient is that? But I showed you before all of the disclosures. It has to be shown when you sell something, and it has the date of it. It has to be disclosed. So there was no way to get away with it. Not only was it sold, it was only $15,000 worth of stock that he says his wife owned, not him. but it still counts. It's marital property, so it's his property too. But his dismissal gets overturned and the case goes back before another judge and gets litigated all over again. It says he ruled in favor of Bank of America, dismissing the case in its entirety without ever advising the parties of the stockholding. When he eventually disclosed it, months after he dismissed the case, it was patently inaccurate. And here's the important bit. The Wall Street Journal asked him about it because it wasn't just this case. There were 13 cases that he did not recuse himself on, that he recognized that he should have disqualified himself from. 13. And that's the ones he admitted. That was in 2022. It's been 3 years. Do you wonder if he's learned his lesson? If he's gotten any better? Remember, he was nominated on May 21st, 2019. He received his commission on December 31st, 2019. He was sworn in on January 1st, 2020. And by the time of this writing, February 2022, so 2 years and 1 month, 25 months. And in that 25 months, he presided over 13 cases that by his own admission, he should have disqualified himself. Do you realize that's like every other month? Plus one, he was taking a case that he shouldn't have taken by his own admission. They say his letter was at best misleading. That's at best. The specific wording, it had come to his attention, and disqualification that is not discovered implied that he had no knowledge of his wife's Bank of America stock until after he dismissed the case. That is not so. And on May 29, 2021, Liman filed his disclosure report for 2020, certified by him as accurate, true, and complete, clearly listing the Bank of America stock. Thus, Liman had actual knowledge of the Bank of America investment at least 5 months before he dismissed the claims against all defendants, and 9 months before he disclosed the stock holding to the parties. And we've seen that he had to state all of this out in 19 in order to qualify to be a judge. So he knew long before. But I remember during the reading that they specifically mentioned a Costco case. I haven't been able to find a list of all 13 cases, but the Bank of America and this Costco case are 2 that actually get mentioned. So when I saw Costco, I was like, oh, is this his? This is not his. It was a different Costco case, but the same time frame. But his wife also, it's always his wife, always blame the wife. He says his wife had stock in Costco while he presided over a Costco case. And this was discovered because he was being investigated because of the Bank of America. Otherwise, he probably would have ruled on this one too. We're supposed to take his word for it that he says his decisions were not affected by his wife's stock ownership. At least that's what they were told by the clerk of court. Nonetheless, that stock ownership would have required recusal under the Code of Conduct for the United States Judges, which we've reviewed already. And he leaves it to the clerk of court to notify the parties that he's already presided over their cases of the potential conflict. He didn't even address them himself. Blame his wife and make the clerk of court contact everybody. Real stand-up guy, Lewis. So guess what happens? This case too, Second Circuit had to order a whole new trial. How much cost has he created for the Second Circuit? A whole new trial in 2020 because he didn't disclose this. Now, when you've done the same thing over and over again, even after getting caught and written up in the Wall Street Journal and in CNN and in The Hill, people whose cases you presided over have to be contacted and told what you've done 13 times. What does that say about you? And I couldn't help but wonder, since all this came to a head back in 2022, has he done it some more in these 3 years? We'll get to that. Then we get to some more shade. But I couldn't help but wonder if they chose the Costco. I mean, it is an excellent case. But they could have just cited Puppo. But I wondered if the little Costco was in there just as a reminder. Because I'm sure every time he sees Costco in a legal filing, it's going to remind him of what he did. And now here's some more shade. We talked about this. Everybody was talking about this. This 50,000 hours, 2,083 days, more than 5.5 years. And he says, citing unidentified public sources instead of someone with actual knowledge. Because how stupid. You're a huge firm. How many juniors are under you? How many interns? How many paralegals? Nobody could have found out. Nobody could have called Wayfair and asked how many hours is this? How many times did they have conversations with Wayfair in this time? Never thought to ask, come up with this ridiculous 50,000 hours. You know what? Lawyers bill by the hour. They should be very fluent in hours. somebody whose job is calculated by the hours. They're used to looking at things in hours. 50,000 should have sounded crazy to them, just like it did me, and made me look it up. But in actuality, Wayfarer says it's less than 150 hours. How ridiculous do they look now? He mentions again, not only does Blake have plenty of time to review the footage prior to her July 17th deposition, she's already very familiar with it because she edited it. Editing entails watching and rewatching the multiple takes of the same scenes, discerning which takes and scenes to use, noting timestamps, creating different versions with different music, colors, and sounds. And as the lead actress, Blake had to memorize the script and performed it in all relevant footage. So she read the script. She had to memorize her lines of the script. She had to act out her lines from the script, and then she edited it. Why does she need to review it again before her deposition? It makes no sense. And what makes even less sense is for the Jones parties, it's unclear what relevance the film footage has to their claims for breaches of contract. And that was my first question when I saw that she was fussing about not having gotten the footage. Why on earth does Stephanie Jones need the footage? She can't even schedule her deposition till she sees the footage. Why? Her claims have nothing to do with the filming of the movie. During the filming of the movie, she represented Wayfarer. And now we have a citing for Recoup LLC versus Outliers. This was a motion to stay, another Judge Liman decision, where he stated that the deposition of Mr. Freed is accordingly stayed until the earlier of a decision by the court, either granting the motion to compel or lifting the partial stay of discovery. Thesis has offered no good cause for why the depositions of the three non-parties cannot go forward. So in this case, Mr. Freed's deposition was stayed because there was an issue with discovery. But these three non-parties were not involved in that. There was nothing preventing it. So he's saying, the other one, yeah, sure. But these? There's no good reason why they can't go forward. The same with Stephanie. Even if Blake had an issue, even if the court decides, oh, she gets to review this footage first, that doesn't mean Stephanie can't go ahead and have her deposition. So says Judge Liman's decision in that case. He also mentions them complaining that the recent document production was deficient or has potential deficiencies. He says no details are provided about what the issues are. They just said there's documents that Blake and Stephanie allege are missing from Miss Abel, Miss Nathan, and Tag. And then, more shade, they acknowledge they already possess, and we mentioned this when we talked about it, through the underhanded Van Zandt subpoena. Remember I said that, oh, you just admitted it. So in their nastiness, they forgot themselves and said, we know you have it because we've seen it. Which admitted that they already had it through this Van Zandt subpoena. And he throws the word underhanded in there, and then mentions that they haven't even attempted to meet and confer about it. And reminds them, not only are we citing all of your own decisions from your own cases, Judge Liman, but we're also going by your own rules. Rule 4C of the individual practices. These are Judge Liman's rules. These aren't rules from something else. These are his specific rules. They're saying, it breaks the rules, it breaks your rules, it should be denied for that reason alone. The last subheading, he says the proposal is untenable. It requests the court to abandon its own discovery dispute procedures set forth in the individual practices, which all parties have efficiently used in favor of a briefing schedule, starting on August 1st. In other words, the motion suggests for the entire month of July, the parties do nothing except tee up discovery motions, regardless of whether those motions are even necessary or will ever be filed. He's saying this is going to mess everything up. We object to this. The parties should utilize the individual practices to adjudicate them. Again says the motion should be denied except to the extent that it seeks to extend the deposition deadline to September 30th. So they're fine with the deposition deadline being moved. That's not really going to create such a big problem. But they do have a problem with the discovery deadline being moved. That stuff needs turned in. Enough. And remind him that they have failed to show good cause to even request it. They state Furry Puppet versus Fallout Boy again, and this Rouvier versus Dupuy Orthopedics. This is even better. This is probably the biggest shade of the whole thing. This is another Judge Liman case. Had a lot of things going on. It was smack in the middle of COVID. It had a million extensions. A lot of things went wrong with the expert depositions. There were problems about discovery. There were a million motions for extension of time, and because of the time period it was happening, they kept being granted. This was a company that produced parts for hip replacements. After a ton of rulings, including the exclusion of one of the experts, that was also a big discovery issue and fight, Liman grants summary judgment for the makers of these medical devices. Can you guess what happens? After they've been ruled against, something gets discovered. Can you guess what it is? Uh-oh. Plaintiff has since discovered financial conflicts that the parties agree warranted the district judge's recusal. When did he decide this case? So he'd had Costco in 2020, that had to be redone. He had Bank of America in 2021, that had to be redone. Then he decided this case even after that in December of 2021. And these poor people. And Liman, who'd only been a judge for 25 months, he had 13, remains a judge. Because of this conduct, the House has to pass a bill to try to make more transparency to stop these judges from presiding over cases where they have financial conflicts and they're not disclosing it. The very month that the bill passes, he's doing it again. He owned Johnson & Johnson, who owned the company who made these devices. Now what happens to these poor people? They file for reconsideration, denied. They want to appeal. Instead of a full closing of the case, reassigning it, brand new litigation, I guess they figure, enough time has passed. Everybody forgot about this. They just assign one of Lewis's colleagues to take over the case, Gregory Woods. They don't relitigate. He does a de novo. We just talked about this. It's seeing a case with fresh eyes. To me, that's for little rulings on simple things, not an entire case, because how do you look at an entire case with fresh eyes? Every step of the way, decisions were made. In this case, there were so many fights over discovery, and especially the expert testimony, that were already an issue, that he decided. A lot of it. There was a magistrate judge as well, but magistrate judges work under the federal judges, remember? So, he was overseeing the whole thing the whole time. You can't just simply say, we're looking at this with fresh eyes, because you don't know what decisions would have been made through the course of this litigation that took years. His decisions affected the final decision. This case should have been completely redone like the others were. But I guess nobody's watching anymore, because this just happened last month, less than 30 days ago. Look at the date on there, June 12th, 2025. The court said, we looked at it with fresh eyes, and we think he made the right decision. Unbelievable. I don't think it's coincidence that these cases ended up in this filing. And it makes me wonder if Wayfair isn't considering making some moves here. We already have this sham lawsuit to deal with. And now we've got this questionable judge. I won't go so far as to say corrupt, but I will say dishonest, because I think it's warranted. It says it in the Wall Street Journal that at best, his letter was misleading. Misleading is another word for dishonesty. When you mislead someone, you make them believe something that's not true. That's dishonest. And they say, at best, that's what he did. It implied he had no knowledge. They straight up said that is not so. He'd already filled in this disclosure report. So Wall Street Journal's calling him dishonest. I think it's fair for us to call him dishonest. And it's such a pattern of behavior. 13 times in 25 months. And now we have another one. How many out there are there that we don't know about? If this case ever slows down, I plan to investigate it. But these filings just never stop, so I haven't had the time to do it, and that's going to be a very big undertaking. In 25 months. This is a problem. Trump, come get your guy. And now we go to document 395. Like I said, this is part of the letter we just went through. One's a letter, one's a declaration. This just states the facts and contains all the exhibits. So it's mostly review. We find out that they served a notice of deposition on Blake. Remember, we had a countdown. She was supposed to be deposed on June 23rd. And so they enclosed that. That tells us when and where that was supposed to be. We only knew that date before. We didn't actually see this then. But now because of this filing, it became part of the record. Then we see that there was a meet and confer where her counsel requested that her deposition be moved to July 17th, which is where it stands now. And we have that as well. And they included as Exhibit B the conversations through emails to show how that happened. They agreed to that. They sent her another notice of deposition. And this is the new one. So July 17th at 9 a.m., and it gives the law office address. And we learned some more information to continue from day to day until completed. So hers may go extra long. She has a lot of claims out there on a lot of different people. They all have the right to depose her. So this isn't just Justin, but this is Jamie. This is Jennifer Abel. This is Melissa Nathan. Jed Wallace's case is separate for now, but we also have the movie. We also have Wayfair. So her deposition could stretch on for a number of days. And then we also learn that it will be recorded by video and stenographic means. When I talked about it before, I didn't know. So I said for sure there would be a court reporter, and video is a possibility. It has to be agreed upon, and apparently it was. So we got a lot more information about her deposition. They served notice on Stephanie that her deposition is supposed to be July 22nd, 2025. That's at the same law office, and hers is the same from day to day until completed, because again, she's suing quite a few people as well, and they all have the right to depose her. And Jennifer Abel had her added as well. They mention again that the Jones party said they're not available. They asked when she's available then, and she has not answered. They repeat in this document, too, that Blake hasn't served notice on anyone for deposition except for Tag, and then she took that one back. They remind the court again that they proposed different dates. For some of them, they notified them on June 24th, and the rest of them on June 30th. Basically showing the court they've done what they could do, and that there's no excuse to extend some of this. And he's not done with the shade. Not only has she refused to schedule the depositions, she's not claimed that she's unavailable. She's not proposed alternative dates. And instead, her counsel alleges they're in the middle of noticing and scheduling additional third parties for depositions. These should have been done a long time ago, first of all. In other words, rather than scheduling the depositions of the Wayfair parties, Miss Lively's counsel is busy, allegedly, subpoenaing various non-party content creators. And there we have it. And just to show they've done their due diligence, they tell the court that they met and conferred on July 2nd. But this little footnote about the non-party content creators goes to an article on Men's Journal showing these subpoenas to Candace Owens, Perez Hilton, and Andy of Popcorned Planet. I'm sure you've all heard that these people have been subpoenaed. And it really just goes to show the priority with Blake. Again, she hasn't bothered to depose anyone about the SH claims. It's all about, I don't want people talking bad about me on the internet. And it's ridiculous. The whole accusation is that there was an invisible smear campaign back around the time of the movie's release. So what does this have to do with anything now? This is not invisible. These are three of the loudest talkers on the internet. They're not hiding anything. Most of the content creators I know, the ones I talk to anyway, go over these filings. Where's the invisible smear campaign? These are public documents that we all can read and share and talk about. Where's the invisible smear campaign? I don't know anyone who talks about this that didn't initially believe Blake. And it was after reading these documents that we stopped believing her and we started talking about this. No one's paying us to do this. Do you see anybody coming up with information that's not public? Where are the leaks? Where are the secret stories? Where are the private details of her life? Who's reporting that stuff? That's what a smear campaign would have looked like. I've said it so many times. If Wayfair were going to smear her, they wouldn't want it to have anything to do with the movie. They wanted that movie to make it. They wanted it to succeed. They worked on it for 5 years. They put up with all of her garbage to get it out there. We saw the text messages of them talking to each other, saying, it'll still be a good movie, even if she ruined this and ruined that. It's still a good movie. It will still be good. I'm still proud of it. That man and that studio didn't want anything to go wrong with that movie. They would not have smeared her at that time, and especially not about things dealing with the movie. People were talking about her appearance in the movie, her clothes, her acting, and her marketing. Wayfair wouldn't have wanted any of those things to be targeted. If they wanted to do a smear campaign on her, they would have chosen other things, not the movie. It was after she fell out of graces and people who weren't her fans started noticing how awful she was and how awful Ryan's marketing was that they started finding other things that she did. And unfortunately for her, she's been a terrible person for a long time. But nobody was paying attention. All of these things were public. Nobody was leaking private things. Nobody was investigating her, following her, catching her in things. It was all publicly available things that started coming out. and being talked about. And when you go back to the cases that were reporting about her clothes and her appearance and her marketing, they're legit TikTok accounts. They're legit reels. They're legit YouTube accounts. They existed before her. They exist now. They talk about all kinds of things. They were not bots that popped up or a troll farm that was controlled by somebody. They were real people with real accounts and real opinions. When you track down a smear campaign, first, you find the accounts that are doing the smearing and you trace them. Where's the suspicious accounts that you think were paid for bots or part of the troll farm? Where are those? Because all I've seen out there is legitimate accounts with legitimate criticisms. How are you going to say those came from Melissa Nathan and Jennifer Abel and Jed Wallace? They existed before. They still exist now. This is insanity. Blake Lively, Ryan Reynolds, we legitimately, organically, because of your own actions, don't like you. We will never support you again. We know who you are now. Nobody's paying us. Nobody's making us do this. He goes on to describe the things that he's done, ways they've tried to make it easier, suggesting the deposition transcripts can be used from Blake to Jones and vice versa. They agreed to extend the 7-hour limits since they're going to be used for both cases. They agreed to do more than 2 a day, but neither Blake's counsel or Stephanie's counsel has said anything about it other than to run to the judge and say, they're limiting the days we can depose him. They didn't give us the film footage. We need extensions. Because of their refusal to timely and properly schedule these, they do need an extension now for the depositions. Again, they say instead of August 14th, September 30th. They're fine with that. But again, they say there's no legitimate basis for extending the deadline for document production. Hand it over. And if ours is deficient, meet and confer with us. Tell us what we need. And this footnote shows they're capable of doing multiple depositions, a couple on different days. Both firms have attorneys on the East Coast and the West Coast. There's plenty of attorneys to get these depositions done. No excuses. He repeats the ridiculousness of the 50,000 hours of video and that it's actually less than 150 hours, and remind the court that she doesn't need to review this before she can be deposed. She claims SH, she should remember without having to see it. And for good measure, it's undisputed that she edited it. She got up close and personal with all of that footage that she read, that she memorized, that she acted, fought over directing, and ultimately edited. Again, with Stephanie, it's unclear what relevance the film footage has to her claims for breach of contract. Neither of them moved to compel. The deadline was July 1st for the substantial completion. It was turned in, and the rest of it is coming this week. So all those accusations that Team Blake put out there, incorrect. Making something out of nothing again. Anyway, this one was full of information, full of shade, and a reminder of what kind of judge Judge Liman is. And it's not good. I'll be working on the rest of these filings. They should all be shorter than this one. This was the longest one. Till then, this is Cassidy O'Connell saying stay well and stay tuned.